6:58 p.m., August the 17th, 1993, Tuesday. Number 238, harassment. Roberta Walsh blasts her horn twice into my dining room window. 7:02 p.m., Candy blasts her horn twice into my east bedroom window. August the 18th, 1993, Wednesday. August the 18th, 1993, Wednesday. To get the 3 police reports, we saw the Assistant District Attorney. Glendora read on television last week Janine Pirro's letter to Glendora. 7:45 p.m., Kevin Larkin and James Walsh were playing ball on the front lawn, where Porzios told them 6 times I know of not to play ball. Glendora showed her lawyer the harassment violations and vandalism and noise violations. A packet was at Glendora's door at 6:45 p.m. Glendora does not know what it was. Mary Ann was here, and the front hall looks so clean now. And Morris says, my son is a born executive. He is only 5 years old, and he already takes 2.5 hours for lunch. Time on wall today is 1 hour. Franklin and Glendora went to the play on August the 19th, 1993, Thursday. Franklin and Glendora went to the Pace Law Library. Cut. August the 19th, 93, Thursday. Franklin and Glendora went to the Pace Law Library and researched civil harassment, fright, emotional infliction, intentional tort. Much of this is on the following pages of this log, number 22. This was a heavy television editing date. 3 programs were worked on, 1307, 1308, and 1309. It took time to work on the log and to read the new material on fright, 1 hour, and it was a day of peace. And what do you call fake spaghetti? What do you call fake spaghetti? The Great Imposter. August the 20th, 1993, Friday. Candy Alpucci came home at 3 a.m. and parked her car under our bedroom window wall, less than a foot from our wall. If that abandoned van were not there, and if they didn't try to squeeze 2 vehicles into the same parking space, she could park over where she belongs, and that's about 7 feet from the wall, and nobody would have heard her come home at 3 a.m. in the morning. Glendora may have found the right legal statement for the cause of action against Walsh, Alpucci, and Larkin. Glendora talked to Porzio. Thursday was a day of peace, so was Friday, until 1 a.m. to 2 a.m. when 6 noisy youths went into and out of Building D. Here is a police report. Franklin Buell, complainant, states that he tried to gain entry with his key into the storage locker in the basement of the above location but was unable to. It appears that some unknown substance was placed in the lock so that the key would not fit in it. The complainant states that this has happened to his apartment door lock before, and it turned out to be crazy glue maliciously squirted into the lock. The complainant feels that this is the same type of incident. This is Officer Coyote. He's really good. He's one of the best of the White Plains Police. I think his badge number is 76. Okay, that's at 21 Greenridge Avenue, and that was on August the 7th, 1993, Saturday. And August the 21st, Saturday, a week later. This has been a day of perfect peace so far, and it is 12:30 p.m. This is the way it should be, and if it continues, all the law work can cease. Glendora spent an hour today on the logs and reading the log, and has found exactly the cause of action to bring against Walsh, Alpucci, and Larkin if there are any more intentional torts. Franklin will be reading them next. Boss, everything in this office is insured except the clock, and the employees keep a close watch of that. August the 22nd, 1993, Sunday. This has been a day of perfect peace so far, and it is 1:30 p.m. The What Happened log is now closing for the week. It has to be printed but cannot be posted until Monday because it will take double postage this week. That'll be 52 cents times 22 people it's mailed to. It's a lot of money. Time today is 3 hours on wall, and for this week it's 10 hours. Glendora will have to videotape the wall update for the television program, and Bob says they have something now at work that will do the work of 5 men. And his mother-in-law says, yes, a woman. Here's another police report. Glendora, a call of damage done to a vehicle at 21 Greenridge Avenue was received. I spoke with Glendora Buell, who states that sometime between well, I don't know what his 2000 is. I would say sometime between 8 o'clock Monday night and 7:30 Tuesday morning. The right front fender was scratched on her 1980 Lincoln Mark 6, New York State 175 TBC. The vehicle was parked in the lot on the south side of the building. Unknown value of damage at this time. Mrs. Buell feels that this may be harassment. No further something at this time. That was Officer Keith Martin. He's very good too. Now here's another police report, and this is Officer Schlesser. And this was on the 14th of August, Saturday, 1993, Glendora. I received a receipt of a dispute. Upon arrival, Glendora and her husband, Franklin, reported that at approximately 5:36 p.m. today, their neighbor, Candy Alpucci, of apartment 4B, blew her car horn 6 times outside the windows of Mr. and Mrs. Buell's apartment. Mrs. Buell feels that this is harassment directed at her by Candy Alpucci for past reports that she has made against Mrs. Alpucci. I was advised that Mrs. Alpucci was not at home at this time. I directed Mrs. Buell to the detective division if she wished to follow up on the matter. So these policemen are doing very well. They write good reports. Now, let's see. About parents and children. Use because of the known propensities of the child or in failing to restrain the child. Now about parents and children. Because of the unknown propensities of the child or in failing to restrain the child from vicious conduct, imperiling others, when the parent has knowledge of the child's inclination toward such conduct, where the parent participates in the child's tortious act by consenting to it or by ratifying it later and accepting the fruits thereof. A great majority of the states have enacted statutes making parents responsible for damages caused by willful, malicious, intentional, or unlawful acts of their minor children. It is provided by statute that except as otherwise provided in certain specified statutes, the parent or legal guardian other than the state or local social services, etc., if such infant willfully, maliciously, or unlawfully damages or destroys real or personal property, or who with intent to deprive the owner of property or to appropriate the same to himself or to a third person knowingly enters or remains unlawfully in a building and wrongfully takes or obtains or withholds personal property from such building, which personal property where the parent knows that the child did it, that the parent is responsible. I don't want to mislead you. We don't have that case here. What we have here is the noise, the breaking of the noise ordinance, and the harassments, where the parent fails to restrain a known mischief or reckless child. Although there have been some decisions in which this principle was not recognized, the general rule is that a parent may be liable for the consequences of failure to exercise the power of control which he has over his children, where he knows, or in the exercise of due care should have known, that injury to another is a probable consequence. A parent is liable for the tortious acts of his child, where the parent's negligence consists entirely of his failure reasonably to restrain the child from vicious conduct imperiling others, when the parent has knowledge of the child's propensity toward such conduct. However, the mere fact that a child aimed a gun at another child and discharged it to the latter's injury does not render the parent cut. That's not the case here. The fact that a parent tries to regulate or supervise the play of his child where the child plays football in the streets does not render the parent liable for injuries inflicted upon another as the result thereof. However, it has been pointed out that there is a distinction between the duty of a parent to supervise such parent's child so as to keep him from hurting himself and the duty to restrain such child from hurting other people, and a parent may be liable to a stranger for negligence in such regard, but not for an injury to the child himself. where the parent consents to or ratifies the child's acts. Now, we've had cases of that too. Not only have the parents consented to the noise that these children make, but they've encouraged it. A parent may be liable for his child's torts where he has knowledge of the wrongdoing and consents to it, or where he directs or sanctifies it, or, of course, where he approves and participates in it. Where he directs or sanctions it, or, of course, where he approves and participates in it. A parent is liable for the tortious acts of his child where the parent participates in the child's tortious acts by consenting to them, or by ratifying them later and accepting the fruits thereof. A person is guilty of harassment in a public place where if he uses abusive or obscene language, a person engages in a course of conduct or repeatedly commits acts which alarm or seriously annoy another person and which serve no legitimate purpose. That's section 1542, harassment. Now, the violation of harassment requires proof of an intent to harass, annoy, or alarm. This intent may be inferred from surrounding circumstances. The statute should be construed as prescribing obscene words and or gestures which substantially annoy a person to such a degree that there would be a direct tendency for that person to react with an act of violence or a breach of peace. When applying this construction, the tier of fact should judge a person's tendency to violence by applying the reasonable man standard, giving due regard to the type of class of addressee involved. A relatively minor utterance of obscenities or fighting words to a complainant can be prosecuted as harassment. Well, we have plenty of those on tape by Candy Alpucci and by James Walsh and by Daniel Walsh and by Roberta Walsh. In order for a pattern of behavior to constitute a course of conduct within the meaning of the harassment statute, it is unnecessary for the defendant to repeatedly commit acts. An information charging harassment is sufficient if the facts alleged constitute a violation of any of the statutory subdivisions relating to harassment. Harassment is essentially similar to the offense of disorderly conduct in that it involves essentially the same conduct, but the conduct is directed toward an individual rather than toward the public in general. So that a complaint charging harassment, like a complaint charging disorderly conduct, is sufficient if the evidence establishes a violation of any one of the subdivisions of the harassment statute. Now, aggravated harassment is the one of calling up on the phone and hanging up with no intention to talk. Makes a telephone call whether or not a conversation ensues with no purpose of legitimate communication. That's aggravated harassment. The gravamen of the offense is the making of the call accompanied by the requisite intent and lack of a legitimate purpose. There is no requirement that a conversation take place. Even if the content of communication by telephone is unobjectionable, a violation of the aggravated harassment statute will occur if the communication is directed at an unwilling listener under circumstances where substantial privacy interests are being invaded in an essentially intolerable manner. A complaint charging harassment, like a complaint charging disorderly conduct, is sufficient if the evidence establishes a violation of any one of the subdivisions of the harassment statute. A court may properly find a defendant who is tried under an information charging him with disorderly conduct guilty of harassment, but disorderly conduct is not a lesser included offense of harassment. Now we have the fright, shock, and mental disturbance law. This article discusses mental suffering, injuries to feelings, fright, and the like as a basis for a separate cause of action or as an element of another cause of action. The article includes a discussion of liability for injury or disability resulting from fright or shock, liability for intentional acts causing mental disturbance, liability for mental anguish caused by insulting or abusive language, or by debt collection practices and liability for negligent acts causing mental disturbance. Also included is a discussion of pleading and evidence in an action for emotional or mental disturbance, as well as a discussion of damages recoverable in such an action. It has federal aspects too. This could go either to the state court or to a federal court. Generally, recovery in absence of physical impact. Freedom from mental disturbance is a protected interest. Damages may be recovered on a cause of action for emotional disturbance. New York law allows recovery for mental disturbance in the absence of a physical impact if the mental injury is marked by definite physical symptoms that are capable of clear medical proof. The presence or absence of an impact is not the decisive factor. Intentional, willful, wanton, or malicious acts. New York adheres to the majority view, which expressly recognizes the existence of an independent tort of intentional infliction of emotional distress. A few states have expressly refused to recognize A cause of action for intentional infliction of severe emotional distress may be maintained. There may be recovery for the intentional infliction of emotional distress without proof of the breach of any duty other than the duty to refrain from inflicting it. One who, by extreme and outrageous conduct, intentionally or recklessly causes severe emotional distress to another is subject to liability for such emotional distress. Liability is found only where the conduct is so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized community. Well, that's what you have with those recordings I played you of Candy Alpucci. Where severe mental pain or anguish is inflicted through a deliberate and malicious campaign of harassment or intimidation, a remedy is available in the form of an action for the intentional infliction of emotional distress. Where defendant's conduct is extraordinarily vindictive, and that's what we have here, it may be regarded as so extreme and outrageous as to give rise to a tort cause of action for emotional distress. And we also have malicious prosecution associated with that. Particular acts are actionable when done without legal justification, or as the rule is sometimes stated, when done maliciously. An action will lie for malicious acts and words where they are calculated to produce and where they do produce damage. One may be held liable in tort for maliciously circulating or giving false information, resulting in intentional injury to another. Although an action will lie for false written or oral statements maliciously circulated for the purpose of injuring another, this is true only if the false statements are not actionable as libels or slanders, either because they are not defamatory or for other reasons. However, there is no liability in tort for doing a lawful act, even though it is done for the malicious purpose of injuring another party, where there are also legitimate reasons for the act. To make a lawful act actionable, it must be entirely malicious without any other motivation and must be directed exclusively toward the injury and damage of another person. Now, we really get down to it. This is Section 3, insulting or abusive language. New York adheres to the majority view, which holds that insulting or abusive language can be actionable. It is sufficiently outrageous to a person of ordinary sensibilities, both where the language is alleged to have caused purely emotional distress to the person to whom it is directed, and where the language is alleged to have caused emotional distress, which in turn produced some physical injury in the person to whom it was directed. It has been held that even in the absence of a contemporaneous bodily impact or injury, or of acts constituting an assault, a cause of action is properly predicated upon a mental or emotional disturbance, or upon a bodily injury or illness resulting therefrom, which is produced by disturbing utterances such as profane, insulting, humiliating, or abusive language. These holdings appear to supplant an earlier case, which held that a plaintiff would be denied the right to maintain an action for a mental or emotional disturbance or for a bodily injury or illness resulting therefrom, which was produced by disturbing utterances, and which further held that even where there was no applicable general rule prohibiting the maintenance of the action, the denial thereof in the particular case could be supported on the basis that the proximate cause of the injury was not the defendant's wrongful act, or that there was no violation by the defendant of any legal duty to the plaintiff, or that the particular utterance was not such as to cause anxiety to a person of ordinary reason and firmness. That's the reasonable man standard. In the absence of evidence that defendant abused or insulted plaintiff, plaintiff is not entitled to recover damages for humiliation, indignity, and distress of mind. Well, we have the evidence. We have plenty of evidence, both on audio tape and videotape. Negligent acts. Under certain circumstances, an action will lie for negligent infliction of severe mental distress. Whether a legal right of the plaintiff has been invaded by the defendant's negligence. Recovery is allowed for mental anguish unaccompanied by physical contact or injury. In an action for a tort based on malicious and wrongful acts of the defendant, where the acts result in substantial damages, the jury is entitled to consider not only the actual money damages, but also such other damages as necessarily arise out of the acts, including damages for mental suffering and anxiety, if the effect of such damage is to produce suffering and anxiety. And certainly that was the intent. Intentional infliction of emotional distress must set forth facts showing extreme and outrageous conduct on the part of the defendant that intentionally or recklessly caused severe emotional distress to the plaintiff. A complaint does not state a cause of action for an intentional tort of outrageous conduct causing mental disturbance where the conduct charged is not so shocking or egregious that it exceeds all bounds of decency or is not of such a character as to give rise to liability. A complaint which purports to state a cause of action for the intentional infliction of mental distress need not plead special damages, nor allege that the defendant's harmful acts be motivated solely by malice. To succeed in an action for intentional infliction of emotional distress, plaintiff must prove that defendant's conduct was so outrageous and shocking as to exceed all bounds of decency as measured by what the average member of the community would tolerate. 2, that defendant's conduct caused severe mental distress to the plaintiff. 3, that defendant acted with a desire to cause such distress or acted recklessly and under circumstances that made it certain defendant knew that mental distress would result. Well, that was certainly what happened here and what you've seen on videotape. Damages. Exemplary damages may be recovered in a common law action for intentional harm for mental disturbance and offense to a plaintiff's personal dignity resulting from an assault and direct violent conduct. So now, folks, we're dealing with a couple of things here. Number one, shall we file a notice of appeal on Judge Catel's decision? If we do, that has to be done by the 30 days are up on September the 8th. You hear about the man who got 30 days in jail so often? He got 30 days so often that the judge wanted to name a month after him. Anyhow, you'd have to do that by September 8th, and that would be the Wednesday after Labor Day, whether we're going to appeal Judge Catel's decision, the upper part. That I didn't have an argument on constitutional rights and that I had to go with the Federal Tort Claims Act and I had to file administrative claims. So that's something to think about. But the next thing is Shrewsbury O'Connell's paper, motion to dismiss my complaint against the negligence of Richard O'Connell, the panel trustee of this bankruptcy suit, in which I'm a creditor, to dismiss my complaint on the basis that you can't sue the trustee. He's an officer of the court, there's no doubt about that, but you can't sue the trustee unless you have permission of the bankruptcy court. So what do you do about that? You go to the Pace Law Library, okay, and you look up everything you can about this matter of having permission to sue from the bankruptcy court. And you start making, first you have to find all the references, and then you have to copy them. Here, I just show you some of this. You have to copy all that. And you have to copy all that. The file on Scott Lord now is up to 4,000 pages, 40 volumes. You have to copy all that. I might just tell you what all that is. Happens to be the Federal Practice Digest, which is really good. And it's on bankruptcy. And many of those were copied, and this is on. So, this took about 6 days to do all this research in the Pace Law Library, and it took about 8 hours a day. Then you have to sit down and you have to write your cross motion. Okay, let's put away this big folder of research. Oh, how long did it take to read all this? That took about 6 days to read it all. Okay, now here is the Scott Lord Atlantis file, 4000 to 4100, and this file was started on the 6th of September 1993. And here you have the answer. And this is the Supreme Court of the State of New York, the County of Westchester, Glendora plaintiff against Conrad Duberstein, Robert John Hall, Andrew Maloney, Harold Jones, who is a United States trustee, former, Neil Mann, who is an assistant United States trustee, former, Teresa Kavanaugh, a current United States trustee over in Garden City, and Richard O'Connell, the panel trustee, Joseph Derby, the marshal, Scott Lord, the bankrupt, the debtor, Jan Stahl and Jeffrey Burns, the two people Scott Lord committed fraudulent conveyances with. Conrad Duberstein is the chief judge of the Eastern District Bankruptcy Court, that's Brooklyn, Nassau, and Suffolk. Robert John Hall is the judge that I said was negligent in handling this case, and he's in Westbury. He's a bankruptcy judge in Westbury. Notice of cross motion, and this is to the Honorable Samuel G. Fredman. That's remember Judge Cattell remanded, he severed the case, okay? Those above, all those federal defendants, the 7 federal defendants, he said everything had to stop, and I had to file a federal administrative claim to 4 agencies about those 7 federal defendants, and then the 4 non-federal defendants he remanded to the state court, where it should have been from the beginning, the whole thing. Please take notice that upon the annexed affirmation of Glendora plaintiff made the 3rd day of September 1993, the accompanying memorandum of law and all pleadings and proceedings herefore and head herein, the plaintiff Glendora shall cross-move this court at the courthouse located at 111 Grove Street, White Plains, New York, on the 13th day of September 1993 at 9:30 o'clock in the forenoon of that day or as soon thereafter as counsel can be heard, for an order pursuant to CPLR 3211B to deny defendant's motion to dismiss the plaintiff's complaint for failure to present a meritorious defense. I claim that they did not present a meritorious defense, and I think you'll agree with that. Dated White Plains, New York, September 3rd, 93. Yours truly, Glendora, Glendora, TB Ads, Box 532, Scarsdale, New York, 10583, 914-949-9495. To Richard O'Connell, Esquire, to Lisa Shrewsbury, Esquire, she's a lawyer for Richard O'Connell, and all others listed on pages 2 and 3, and to Glendora's TV audience. That's you. And here's pages 2. This is the 17 defendants, and their lawyers and the judges, and this is the 19 non-defendants, and these go to Washington, D.C., a whole lot of them. In all, it's 36 people who will receive this motion, cross motion. Affirmation in support of plaintiff's cross motion. 1. O'Connell Shrewsbury state that Glendora has to have the permission of the bankruptcy court to sue panel trustee Richard O'Connell. They are wrong. The law says just the opposite. Point A. Now this is what is it? Is it Title 11 or Title 28 of the United States Code? Section 959. And here's what it says. Trustees, receivers, or managers of any property, including debtors in possession, may be sued without leave of the court appointing them. This is the citation she gave, Section 959. And it says just the opposite. It says trustees can be sued without the leave of the court appointing them. with respect to any of their acts or transactions in carrying on business connected with such property. Such actions shall be subject to the general equity power of such court so far as the same may be necessary to the ends of justice, but they shall not deprive a litigant of his right to trial by jury. A trustee, receiver, or manager appointed in any cause pending in any court of the United States, including a debtor in possession, shall manage and operate the property in his possession as such trustee, receiver, or manager, according to the requirements of the valid laws of the state in which such property is situated. These are two very important points. See, we're back in state court now with Judge Fredman. In the same manner that the owner or possessor thereof would be bound to do if in possession thereof. This is my page 2. Glendora does not need the permission of the bankruptcy court to sue panel trustee O'Connell. And here's a citation. Approval of permission of the bankruptcy court. Prior authority of bankruptcy court is not necessary before party may institute suit against Chapter 7 trustee, and that's what Richard O'Connell is. And the citation, the bankruptcy case on this is Reich, R-E-I-C-H, and it's in the bankruptcy books of Michigan of the Eastern District, 1985, and it's in volume 54 of the Bankruptcy Reporter, page 995. So I say that takes care of that. And further, this section 959, I just read you, the trustee of a bankrupt corporation is a proper person to an action previously begun by stockholders to set aside a transfer of rights by the corporation, and he may be either plaintiff or defendant, and in either event it is immaterial that he is in no position to question the validity of the transfer because there are no creditors who became such before the transfer was made. Muller versus Pirro, 1929. And that's also in the Bankruptcy Report. That's just another case in support, showing that you can sue the trustee, and you don't need the permission of the bankruptcy court to do that. Here is the case of Reich. In re, Kenneth F. Reich and Sophine J. Reich, debtors, estate of Kenneth F. Reich, deceased, and Sophine J. Reich, plaintiffs. And James Burke Sr. and Travelers Indemnity Company are the defendants. And it's bankruptcy number 81. This is 1981, United States Bankruptcy Court, Eastern District, Michigan, November 18, 1985, is when this decision was made. Chapter 7, debtors filed suit against the trustee of estate and against his bond for trustees' alleged negligence in failing to preserve property of estate by failing to remove or have removed snow from the roof of the building. Well, this is like my case in that I claimed the case, except that it's the creditor suing the trustee, but it is for negligence. Now, right here, bankruptcy. Section 285, prior authority of the bankruptcy court is not necessary before the party may institute suit against a Chapter 7 trustee. Bankruptcy Code, Title 11, United States Code, applied, A is applied or annotated, Section 701, and what follows. And here is the case. I included this case for Judge Fredman. Front and back. And also we have, and then I go through here and I cite all these cases where trustees were sued. And the very law that Shrewsbury and O'Connell invoked turns out to be their enemy. And here's some more of them. There certainly are enough of them, folks. This came from that federal practice digest I told you about. Permission of the bankruptcy court to sue the panel trustee, Glendora does not need. Plaintiff Glendora does not need the permission of the bankruptcy court to sue panel trustee Richard O'Connell's negligence in the handling of Glendora's interests as a creditor. There are a multitude of cases proving this. See the following. Now here's point B. This is a very important point. By res judicata and collateral estoppel, Glendora does not have to have the permission of the bankruptcy court to sue this trustee O'Connell. Judge Schwartzberg, remember, has already ruled that the case does not belong in the bankruptcy court. He ruled that on June 4th, 1993, Friday. Remember that? You have a copy of this decision. Judge Gattell endorsed Judge Schwartzberg's decision on June the 7th, 3 days later, on Monday. Same decision. Glendora's case does not belong in the bankruptcy court for the reasons that Nowitzki has given. Then I go through and I quote what Nowitzki says. The main thing is that, well, she's saying that it's a non-court proceeding, but she's saying it does not come in with any of the categories of matters subject to reference under 157A. It is not within the jurisdiction of the bankruptcy judge. Anybody can say that. The only court that could have subject matter jurisdiction over this action is against the federal defendants is the United States District Court. The gravamen of the complaint is that certain actions or omissions on the part of the defendants in connection with a bankruptcy case and an adversary proceeding commenced in another judicial district constituted negligence. The bankruptcy case, In re Atlantis Lawn Sprinklers Company, Inc., case number 890-80195-478, was brought to the Eastern District of New York. Plaintiff, a creditor in the In re Atlantis Lawn Sprinklers proceeding, characterizes this action as seeking damages for negligent handling of her interests as a creditor and for negligent infliction of emotional distress. Summons with notice at 2. In fact, plaintiff has carefully included the word negligent, quote unquote, in each and every paragraph of her complaint. The wrongs that are alleged are common law torts, and the only relief sought is money damages. ID. To the extent that the complaint states a claim at all, that claim must be recognized as sounding in tort and not in bankruptcy. Clearly, this action cannot be characterized as a case under Title 11 or as a proceeding arising either under Title 11 or in a case that arises under Title 11. Therefore, in order to be subject to reference to a bankruptcy judge under Section 157A, it would have to constitute a proceeding related to a case under Title 11. Okay. She goes on to say, jurisdiction encompasses only disputes that affect the payments to the bankrupt's other creditors or the administration of the bankrupt's estate. Plaintiff's action does not satisfy this test. Plaintiff seeks neither payments from the bankruptcy estate nor payments to any other creditors. Rather, she simply seeks money damages to be paid by non-debtor defendants. Because the resolution of this action would not affect the debtor's rights or liabilities and would have no effect on the distribution of the property of the estate, this action is not related to a case under Title 11. Title 11 is the bankruptcy title. The law, rules, and code. Accordingly, Section 157A does not authorize the reference of this case to a bankruptcy judge. You know what I also should have included here to Judge Fredman, although he has it already, is Judge Gattell's statement after that, that although this concerns bankruptcy personnel, it is not a case that goes before the bankruptcy court. The bankruptcy judges in this district have no familiarity with the facts because she's talking to the Southern District, which has a branch in White Plains, and this bankruptcy started in Nassau County in the Eastern District. Okay. Now, here are some more cases where trustees were certainly sued. And this is point C by Glendora. And I think this is an important point, folks. Requiring the permission of the bankruptcy court to sue is antithetical to the Federal Tort Claims Act. 40 years ago, the United States gave up its sovereign immunity with the Federal Tort Claims Act. It waived, I'm the king, and you can't sue me without my permission. The United States waived that. That's called sovereignty. It came from England, of course. Under a long-established rule, an action cannot be maintained against the sovereign without his consent. Accordingly, in the absence of a specific provision admitting liability, the United States is not liable for injuries arising from the negligence or other tortious conduct of any of its officers, agents, or servants, though the allegedly wrongful acts were performed for the benefit of the public. With the enactment of the Federal Tort Claims Act, Congress provided a comprehensive remedy against the United States for personal injury, death, or property damage resulting from the negligent or wrongful acts or omissions of federal employees while acting within the scope of their office or employment. Now that's for you. You can sue the United States. This personal injury, this comes under, this negligence that I'm complaining about comes under personal injury. Civil actions on claims against the United States for money damages for injury or loss of property or personal injury or death caused by the negligent or wrongful act or omission of any government employee while acting within the scope of his office or employment under circumstances where the United States, if a private person, would be liable to the claimant in accordance with the law of the place where the act or omission occurred. That's where you get into state law. This has to follow the laws, state laws of New York. The Federal Tort Claims Act, it has been observed, was not patterned to operate with complete independence from the principles developed by the common law and refined by statutes and judicial decisions. That's the three sources of the law, right? The common law, sometimes it's never written down. The statutes, those are what you find in CPLR, and judicial decisions, that's a case law. That's what all this stuff is that I quoted. The Federal Tort Claims Act does not prohibit suits against government employees based on personal liability for their torts, even though committed in the course of their employment. You can still sue these other people personally. In certain instances. We ought to really explore that because Novinsky maintained and Judge Gattell agreed that I could not file my suits against the 7 defendants, federal defendants personally, that it had to be through the Federal Tort Claims Act. And she may be right about that and she may be wrong. Now, it is just not reasonable, Glendora says, that the United States waives its immunity and the bankruptcy court does not, because this is a United States bankruptcy court. This invocation of reason, therefore, wipes out the anachronism of O'Connell-Shrewsbury, quote, you have to have the permission of the bankruptcy court to sue a trustee. Then, the next thing I have to do is to go on to the cases that Shrewsbury cited, the citations, the authorities they're called. And I go into the Campbell case, and I say about the Campbell case that O'Connell states as an authority, the concept of, quote, carrying on business, unquote, is not applicable here. O'Connell was carrying on business at the time O'Connell committed all these negligences. He had an adversary proceeding going against Scott Lord, Jan Stahl, Jeffrey Barnes, Tri-State, for fraudulent conveyances. So what the Campbell case says that there wasn't any business going on. And so the Campbell case saying that you have to have the permission of the bankruptcy court to sue the trustee, but there was no business going on. So the Campbell case does not apply to this case. Further, Campbell is not relevant since both Judge Schwartzberg, a bankruptcy judge for the United States, already ruled the case did not belong in bankruptcy court and was backed up by Judge Gattell's memorandum decision. Ginny is playing with a microphone cord. About Voss, that's the second case, or a case. About Voss, authority that O'Connell invokes, the date of this decision is 1932. That's 60 years ago, folks. It is 20 years before the Federal Tort Claims Act, waiving United States sovereignty, immunity to being sued, giving people like Glendora a way to defend herself against government negligence. And here again, it's carrying on business. It's saying that Voss was not carrying on business. Well, in this case, O'Connell was carrying on business. Trustee O'Connell was doing a whole lot more than Trustee Voss. Trustee Voss was not carrying on business. Trustee O'Connell was. So here's all the citations on that. Now, There is something in Voss that does apply to this case. It says New York doctrine that action is not maintainable against trustee as such held inapplicable to the bankruptcy trustee. Such doctrine is inapplicable to trustees in bankruptcy, who may be sued by their title and judgments against whom can be bind the assets. Every receiver or manager or trustee of any property appointed by any court of the United States may be sued in respect of any act or transmission of his in carrying on business connected with such property without previous leave of court in which such receiver or manager was appointed. There it is again. It cannot be plainer. O'Connell was carrying on business, and permission of the bankruptcy court to sue him is not needed. O'Connell is wrong. His defense has no merit. And Glendora's refutation of the Voss case as applying to Glendora's case. Now we go on to the Barton case. The Barton case is a big case at Supreme Court, United States Supreme Court. Barton's case against trustee Barber does not apply either. This is a worry of the Supreme Court, the United States, that Barton would be taking property out of the bankruptcy estate. Well, we've already pointed out that this case does not take property out of the bankruptcy estate. This is not the case with the Glendora case. She would not be taking money out of the bankruptcy estate. Barton is a case between two states, the state of Virginia and the Supreme Court in the District of Columbia. Glendora's case is not between two states. It is all in the same state, the state of New York. Here's Jeannie Cat. Yeah, hello, Jeannie Cat. Look to the people. I'm glad you stopped playing with the microphone cord. Microphones are expensive, Jeannie. So, this, a cat can always find out what you're doing and sit on it. So this is not a case between two states. Everybody concerned is in the state of New York, one state. And again, remember that both Judge Schwartzberg, a bankruptcy judge, and Judge Cattell, a United States District Court judge, have ruled that the case of Glendora does not belong in bankruptcy court. Judge Cattell has ruled this twice even. If the case does not belong in bankruptcy court, why do you have to have the permission of the bankruptcy court to sue O'Connell? Without regard to other creditors is the case with Barton and figured in the decision, but is not the case with Glendora, and the Barton decision does not apply in Glendora's case. Further, the Barton case is not relevant to Glendora because if Glendora sought the permission of the bankruptcy court to sue, she would be asking the same people she sued, Judge Hall and his boss, Judge Duperstein. She would have to be asking the defendants, is this justice? Further, if Glendora's action against O'Connell ended up in bankruptcy court, and remember, both Cattell and Schwartzberg took it out of bankruptcy court, Glendora would, that would be three times. That would be three rulings. Judge Schwartzberg once, Judge Cattell once, and Judge Cattell twice. Glendora would not have a trial by jury. Oh, this is an important point. Because bankruptcy courts do not have a trial by jury, and this is denying Glendora a fundamental constitutional right, trial by jury. This point continues to weaken the Barton case applying to the Glendora case by Justice Miller's dissent on this very matter of trial by jury. Justice Miller was a Supreme Court justice, and he wrote a long dissent. And he would not agree with the other judges. And he said, and the reason is that it was a denial of this basic constitutional right. You know, goes way, way, way back to the Magna Carta even, of a trial by jury. Mr. Justice Miller writes a long dissent against the Barton decision for permission of the bankruptcy court to sue. This Barton case is older than my mother. My mother's birthday is today, September the 1st, 1993. She would be 105 years old. The Barton decision was written 7 years before she was born. The law has changed a lot since then. This Barton decision was written 72 years before the Federal Tort Claims Act, which waived the, quote, "You need my permission to sue me. Certainly the United States Bankruptcy Court comes under that." This is not United States, this is Gestapo. This is narcissism. Shrewsbury O'Connell are asking Glendora to get the permission of the same court that is a defendant. This is going to sound great on television, and here it is. Let's hope America's youth don't hear it. Tune out, America's youth. Let's hope that enemies of the United States don't get a hold of it. Tune out, enemies of the United States. Change the channel. Barton is a railroad and for the public good. Atlantis Lawn Sprinkler, Scott Lord Company, and Scott Lord are hardly the same. The public is not deprived by the end of Atlantis Lawn Sprinklers. or of Scott Lord. There was no taking of rights away from the public. In a railroad, there is. The public depends upon it for transportation. Further, the Barton arguments are in conflict with the arguments in the decisions of both Voss and Campbell. So let's go on to another authority that they cite, the Baptist Medical Center in Manhattan. All of the rulings in this case are in Glendora's favor except the one about the bankruptcy case, and that has been refuted. Glendora does not need permission of the bankruptcy court to sue O'Connell. Judge Schwartzberg ruled once and Judge Cattell ruled twice that the Glendora case does not belong in the bankruptcy court. We go on to point E. And now, if nobody minds, could we please get back to the issue, the negligences of the trustee, which the lawsuit is actually about. This is terrible about the courts. They get derailed, they never talk about the issue, they never talk what you're there for to try to get justice for. They just go around and around the perimeter and they never penetrate the core. And now, as Elizabeth Barrett and Robert Browning would put it, quote, "Let me count the ways the panel trustee O'Connell was negligent and still is. Dozens of trustees have been sued for the same cause of action Glendora sued panel trustee Richard E. O'Connell. Dozens. There's a few more. This is what you call the case law. Here's just a few more, and here's just a few more cases. Now, Trustee O'Connell was negligent to minimize for the creditors instead of maximizing the estate. You remember we had a $105,000 judgment against Tri-State Jeffrey Burns and Jan Stahl? The trustee downsized that to $5,000. Is that maximizing? No, I would say that's minimizing. Do you remember we had a judgment against Scott Lord for $55,000 and the trustee wormed out of that at $12,000? And now we have point 3, as if that isn't enough. Trustee Richard O'Connell is negligent in taking so long to resolve this bankruptcy. Folks, it is almost 4 years. Scott Lord filed 2 petitions, bankruptcy, back to back, on January 30th, 1990. And this is September 1993, so we're coming up to 4 years. And that's in addition to the personal bankruptcy, Chapter 13, that he filed in 1985, he and his wife, Ariella. 4, Trustee O'Connell was and is negligent in not keeping in the clerk's office for public view when the bankruptcy law says this shall be done, and in making Glendora fight so hard to get any information. You remember all the fights I told you I've had with O'Connell and the people in his office and with Kavanaugh, United States Trustee Assistant? Remember all that? They won't give the information, and they're required by law to do so. I shouldn't even have to ask them for it. I should be able to go to the clerk's office in Westbury, the United States Bankruptcy Court, where Judge Hall is, and I should be able to pull that stuff from the files and read it. He should keep a record, and he doesn't. He's negligent. Trustee was grotesquely negligent in telling Glendora to ask his lawyer, Shrewsbury, for the information. I kept asking, is Scott Lord current in his payments? He wasn't. And the trustee kept covering that up. And Kavanaugh kept covering it up. They didn't want you to know and me to know that he wasn't current in his payments. Let me put this down. Let me read this to you. This is Bankruptcy District of Puerto Rico, 1987. Chapter 7 trustee cannot delegate his duties to his attorney or another professional. And you remember, I told them that over the telephone, that a trustee has a personal relationship in a bankruptcy. He and he alone is in charge. He and he alone is responsible, and he has to give the creditors the information they seek. Glendora does not know how large a blanket bond that Trustee O'Connell paid because he does not keep the record. The trustee has to pay a blanket bond, and he should have put it in the record how much he paid. 5, the trustee is negligent in not treating Glendora as a creditor should be treated. And see, these are all of the duties of a trustee that have been tried in the courts. Glendora does not know if the creditors are paying the fees of Scott Lord's lawyer, Janowitz. Why doesn't she know? Because the trustee does not report that information. 6, negligent examining books. The trustee did not make Scott Lord produce any books at all. Scott Lord got by saying, oh, there was a flood. That's one of his excuses. He has flood, he has fire, he has snowstorms, he has backaches, he has hospital trips, he has deaths. He has quite a few stock excuses. And they appear everywhere, in the district attorney's office in Nassau, in the consumer affairs office, in the sheriff's office, the same excuses over and over again. So anyway, O'Connell didn't make Scott Lord produce any books at the 341 meetings. The 341 meetings are the meetings where the trustee and the creditor, well, the trustee is elected, that's one of the things, although we never had an election. And also at the 341 meetings, that's when the debtor appears and the creditor can question the debtor and determine assets, and the trustee, that's his job to do that too. And this is more negligence in providing the creditors with information. We do not know if we ever got a prompt review from the 341 meetings because Trustee O'Connell did not report that. We do not know who is paying for Shrewsbury. That's O'Connell's lawyer who wrote this paper that I'm refuting. O'Connell does not tell us. Glendora never saw any such information about Trustee O'Connell, never provided it. This is a report of a conclusion of the first creditors meeting. See, and here's more law cases about this. This is what you call the case law, right? 7, Richard O'Connell was negligent in not pressing the United States Attorney for a criminal investigation when we knew, and he knew full well, that Scott Lord, Barnes, and Stahl had committed fraudulent conveyances, which is a crime. 8, Richard O'Connell was negligent in not doing anything about the assets Glendora found and that were not declared. I found many trucks and many vehicles. I gave him the registration numbers. One truck was being hidden, and another creditor called me up and told me where it was. I went out to Nassau County. I found this truck, and I told the trustee where it was. Pretty soon that truck ended up on the tri-state property in West Hempstead on Center Street, just 2 doors from, actually it's juxtaposed, to the district court. All of this goes on right under the nose of the district court in Hempstead. Richard O'Connell was negligent in not prosecuting Scott Lord for missing over 8 341 meetings when Glendora traveled all the way from White Plains to Westbury and paid all those tolls going over the Throgs Neck Bridge and paid all that gasoline and took all that time. It took a day each trip. And I never missed one of them. But Scott Lord missed 8 of them, and Richard O'Connell did nothing about it. One time Richard O'Connell said, I'll issue a summons, a subpoena, I guess it was, for his appearance, and I went to the 341 meeting. No, Scott Lord. I said, what happened? He said, it just didn't happen. I said, you were going to issue a subpoena or a summons for him to be here. What happened? He says, it didn't happen. 16, the above listed negligences and the other negligence listed in Glendora's complaint constitute Glendora's cause of action for damages against O'Connell for $10,000. $50,000, since this case has been severed, the damages now, I split them this way, $15,000 for the federal defendants, $12,500 for each of them, the judges, the trustees, the marshal, and the United States Attorney, Andrew Maloney. And then that leaves $30,000 in the Supreme Court, $10,000 for O'Connell, and I believe it's $12,000 for Scott Lord, and $4,000 for Jan Stahl, and $4,000 for Jeffrey Barnes. Point F, Shrewsbury and O'Connell did not offer any exhibits or any proof that the panel trustee O'Connell did not commit these negligences. The only exhibit they sent Judge Fredman was Glendora's summons with notice and complaint, which Judge Fredman had long ago. Defendant O'Connell presented no meritorious defense. And that's statute law, CPLR 3211B. This is Ginny Cat, our little charcoal gray kitty. And she's sitting on all of the Scott Lord legal papers. Point G, if Glendora's case against Richard O'Connell is dismissed, then she will ask the permission of the bankruptcy court to sue Richard O'Connell, as if what has happened so far has not been ludicrous enough for the TV audience. All the papers are reported on TV, plaintiff, defendant, and judge. They are half-hour programs. 3 chapters have been televised in Manhattan. Nassau County is next. Then comes TCI Westchester. Then comes Cablevision Westchester. Chapters 4, 5, 6, 7, and 8 are ready to be telecast. Chapters 9, 10, and 11 are being edited for television. And this series will be on TV for 3 months. 1 half-hour each week. And Ginny will still be on the desk. Glendora has submitted her administrative claims to 4 federal agencies for damages against the 7 federal defendants, 2 judges, 3 U.S. trustees, the United States Attorney, and the Marshal. All of this arises from Scott Lord, who lied, stole, and cheated Glendora 7 years ago, this very September 8th, 1986. Today, folks, is September the 5th, 1993, Sunday Communion, and on September the 8th, 1986, 3 days from now, it'll be 7 years since Scott Lord lied, stole, and cheated Glendora, and got out of it in 1986 of a bankruptcy law that is a monster, a bankruptcy law that is a monster, whose administration is abysmal and whose trustee system is abominable. Wherefore, Glendora, wherefore, pages 1 to 32 do state a cause of action, and plaintiff Glendora pleads that this court deny Richard O'Connell's motion to dismiss Glendora's complaint of negligences, grant Glendora's cross motion to dismiss Richard O'Connell's motion to dismiss, grant Glendora's $12,000 for damages incurred by these negligences, grant Glendora the costs of this action, and whatever further relief this court deems proper, dated White Plains, New York, 1058, dated White Plains, New York, September 3rd, 1993. Yours truly, Glendora. Glendora TV Ads, Box 532, Scarsdale, New York, 10583, 914-949-9495. Subscribed and sworn to before me this 3rd day of September 1993, Mary Natoli, who was the court clerk for Judge Gordon Burroughs, Justice Gordon Burroughs. To all the people listed on pages 2 and 3, and to Glendora's TV audience. And we have an appendix. In the appendix, questions unanswered. Was Richard O'Connell ever sanctioned? 2 cases of trustees being sanctioned. 2, did Glendora ever doubt or question Richard O'Connell's honor, honesty, or integrity? No, never. Only his negligences. These are cases where trustees' honor and integrity were questioned. 3, does Glendora like Richard O'Connell? Yes, very much, and always has since January 1990. 4, is there anything improper about Richard O'Connell's law firm being the attorney for Richard O'Connell? 5, is the relationship between panel trustee O'Connell and bankruptcy judge Robert John Hall correct? Is it, Ginny? Is it? And these are cases about the relationship between the judge and the trustee. Just a little point of information there. This whole trustee system was sort of a new thing. They started out, 8, 9 decades ago, that the bankruptcy judge should not administer the bankruptcy affairs. And it sort of makes sense. The bankruptcy affairs should go to a trustee because the judge should not be handling both of them. It's conflict of interest. But I still say their trustee system is abominable. Was Richard O'Connell a trustee for two Scott Lord Chapter 7s? Yes, back to back. And he closed the first one too fast without any explaining. It was just closed like that, and now it's down in the files in Bayonne, New Jersey. That's where it's not even out in Westbury anymore. So if I wanted to see that file again, I'd have to go to Bayonne. And what does this mean? A bankruptcy trustee's position does not empower him to bring suits personal to creditor. Does Assistant United States Trustee Teresa Kavanaugh live and work by this? No. Stay tuned. United States Trustee must be very circumspect in his conduct, this is in her conduct, regarding individual cases, although it is unconstitutional for her to exercise judicial functions. I have found her not to be a good United States trustee at all. Assistant, that is. Could Glendora remain silent? No, not about these negligences. Now I'll read you this case. A creditor which knew of the trustee's ownership of stock in the creditor as trustee in another bankruptcy case at least 2 years previously was stopped from arguing conflict of interest as grounds for removal of trustee on a basis of his failure to raise objection until trustee's commencement of adversary action against creditor. So you see, you can't remain silent. When you see these things, you have to mention them. Is the right word for it? Is this the right word for it? Yes. And for all involved, and I'm going to read you. You see that underlined word right there? I'll read it to you. Evidence established Chapter 11 trustee acted out of avarice, seeking his own benefit in continuous violation of the bankruptcy code by granting economic benefits to some parties and prolonging economic agony of debtor. That is exactly the right word for this. It is agony. It is agony for everybody. And I say here at the end, and I think this is my final word. Oh, unfortunately it isn't. That Congress should put a moratorium on all bankruptcies. Yes, immediately. Have you heard the good news? Other courts have not relied on this precept as a barrier to recovery under the Act. For example, courts have held, this is under the Federal Tort Claims Act, courts have held that liability may be imposed under the Federal Tort Claims Act for the more recently recognized tort of intentional infliction of emotional distress. And 12, this is the last point. It says that it would be presumed improper to appoint single trustee, single creditors committee, or same counsel for trustee. And I say, does this apply to panel trustee Richard O'Connell? No, he is not single, he is married. Just a little joke. And Glendora cross motion to dismiss, Shrewsbury O'Connell motion to dismiss Glendora's complaint of negligences. And the last page is the affidavit of service. And it was served. It was all signed. It was finished, signed, notarized, and served, all on the same day, the 3rd day of September 1993. And that's really the only honest way to do it. People date their papers one date and serve it the other day and hope that they're going to get by with the earlier date because the paper was dated so-and-so when it really wasn't served until 10 days later. And the other party didn't get the paper until maybe 3 days later. So that is the cross motion to Judge Fredman to dismiss O'Connell Shrewsbury's motion to dismiss my complaint on the basis that you have to have permission of the bankruptcy court to sue the trustee. It is not so. So the next thing, of course, I have to file the Federal Tort Claims Act. I have to file the administrative claim. And here they are. I filed 4 of them. The Executive Office of the United States Attorneys, Department of Justice, that's called USAO, and of course that would be for Andrew Maloney, former United States Attorney in our area. L. Ralph Meckham, Director, Administrative Office, U.S. Courts, 1 Columbus Circle. These went out about the middle of August 1993. That would be for the 2 judges, Judge Duberstein and Judge Hall. And this one is the General Counsel, Executive Office, United States Trustees. That would be Martha Davis, you know who she is. And so that would go for Kavanaugh, Jones, and Mann, United States Trustees. And the last one is the Senior Associate General, Counsel for Litigation, U.S. Marshal Service, and that would be for Marshal Joseph Derby. Now this form is a very simple form to fill out. It's 1 page, and over in the back there's 2-3 questions, yes and no. And it's as simple as that. You send it to the agency, and the agency has something like 6 months to accept your claim or to deny it. And if you don't hear from them in 6 months, you can assume that it's denied. Then you can go ahead and sue. So that's what I'll do. If they don't settle the claim, and I brought these claims down to $12,500 for the 4 agencies, $12,500 for each. You divide $50,000 by that. And if you don't hear from them in 6 months, then you go ahead and sue, and that's what I'll do. I'll go ahead and sue again, and I'll sue in the United States District Court, and it'll be again Judge Cattell, and that'll be in the White Plains branch of the Eastern District, of the Southern District, New York. Here is the form, folks. As I say, it's very, very simple. It asks you 4, 5, 6 questions. They want to know if you're married. They want to know when you were born. I said, see attached, what my complaint was, and that, of course, is my whole complaint of 22 pages. And the name of a witness, and your telephone number, and your signature, and the date that you signed it, and they want to know about insurance, and these answers are very simple on the back. No, no, no. So, that's how simple it is to make a claim against a government agency, United States government agency. And now I will read you, I had to tell Judge Cattell this, that I sent out these claims. So I'm going to read you that. Honorable Gerard L. Cattell, this is the United States District Court, Southern District of New York, Glendora plaintiff against Conrad Duberstein, Robert John Hall, Andrew Maloney, Harold Jones, Neil Mann, Teresa Kavanaugh, Richard O'Connell, Joseph Derby, Scott Lord, Jan Stahl, and Jeffrey Burns. Even though the case has been severed and 7 of these defendants are in the United States District Court, the other 4 were remanded to the state, New York State Supreme Court, Westchester County. Honorable Gerard L. Cattell notice. This is a notice that Plaintiff Glendora has filed 4 administrative claims. The claims were posted on August the 28th, 1993, Saturday at 8:31 a.m. The claims went to the 4 agencies listed on the next sheet. Those are the tops of the sheets that I just showed you. This was a bad move on the part of Novinsky and the federal defendants. It spread the infection of these bad acts from New York State, Westchester County, Nassau County, and New York County to Washington, D.C., our nation's capital. But then, what has Glendora been saying about these people for 6 months? And now they are going to blame the United States for their negligences. And the whole record is set before the television viewers. Every paper has been read to them. The first 4 chapters have been televised in Manhattan. Next is Nassau, next is Westchester. And so far, there are 10 chapters, 1/2 hour long. Now, if the agencies deny my claims in the next 30 days or just ignore them for 6 months, Glendora will be back in district court to stand up for what is right again, and to see what devices Novinsky can come up with this time to obfuscate the issue. Glendora has not decided whether she will appeal your decision. The Federal Tort Claims Act mentions that under extenuating circumstances, the requirement to file an administrative claim can be waived. And certainly, taking my case, out of Supreme Court twice, double kidnapping, and changing the rules Glendora filed under in Supreme Court constitutes extenuating circumstances. I think Gattell could have ruled that way. Something could have been allowed there. Further, to let these federal defendants go from April the 23rd to July 23rd without answering a summons with notice and complaint has to be questioned. How can they get away when they're given 20 days to answer? How do they get away 2 months without answering? Something's really rotten in Denmark there. And that you could not see where my constitutional rights were being violated. I'm talking to Judge Gattell. And you, a federal judge, has to be examined. You can see what the plaintiff has been through with all these negligences for nearly 4 years. The record of it is in your file. You could have awarded the damages. The record is this big of what Scott Lord has done, Jan Stahl and Jeffrey Burns and Richard O'Connell and Judge Hall. Your anti-pro se position has to be challenged. You will not hear an oral argument from a pro se. That is denial of due process by the 5th and 14th Amendments. In an oral argument, you can tell who is lying and who is telling the truth. Judges have to be very good at that. Who is wrong and who is right. This not seeing anybody eyeball to eyeball is like a correspondence school. Glendora made $5,600 this week paying attention to her TV advertising business and taking some time off from standing up for what is right. Think of the turmoil and hard work that this cheat, Scott Lord, has caused you and the rest of the government and this poor victim, yet he is scot-free. Glendora will, if she can, find the time, be in your courtroom to monitor. You have interesting cases and you work hard, and what you say is interesting, and you button your robe on your way into the courtroom to the bench. On the oral argument, I could have heard what you were thinking, and I could have stated then when it was going in the wrong direction. Novinsky did not include an affidavit for Judges Duberstein and Hall that Glendora had not filed an administrative claim. The right office is MECOM, United States Courts Administration. And there goes Ginny again playing with the microphone cord. What is bad about Congress insisting on an administrative claim before litigation is that you have to submit the claim to the very agency who caused the injury. And you get no pretrial and discovery tools of the Federal Rules of Civil Procedure. And the witness recollection of the events gets dimmer and dimmer. And the people involved may get transferred or may get dismissed. See, this is the problem with waiting so long to have your claim discussed. The dismissal for failure to file an administrative claim is not a dismissal on the merits. Dismissal will be without prejudice, and the doctrine of res judicata will not bar a subsequent suit by the claimant. So this is just a hiatus. Glendora will be back in 6 months or less. Glendora still cannot see why these federal defendants would not be sued in state court. There was no diversity of citizenship. That means they were all in the same state, you know. Some of them didn't come from New Jersey, and some of them didn't come from Connecticut. They were all in New York State. There was no diversity of citizenship. All the litigants were residents of the same state. Defendant waived the right to remove by filing an answer in state court. O'Connell filed an answer in state court. Okay, what I'm doing now is testing this and seeing if I can record without that breakup in it. Did you see that breakup in the tape? That's a queer thing. You always have to look for the problem. It could be in the camcorder, it could be in the tape, it could be in the heads. Usually it's in the tape. And so the first thing you have to do is clean the heads with the head cleaner, the Canon head cleaner. And then you see if that gets it out, and it didn't. So then you stop it and you record again and see if you can record without that breakup. And in this case, that's what we did. So I was saying, the dismissal for failure to file an administrative claim is not a dismissal on the merits. See, Judge Cattell did not dismiss my complaint on the merits. Dismissal will be without prejudice. That means that you can do it over again. If it's with prejudice, you can't do it over again. And the doctrine of res judicata will not bar a subsequent suit by the claimant. That is, that it's a res judicata, it's already been adjudicated, it's already been decided. So they won't let that apply when you bring a suit and you haven't brought a claim yet. So this is just a hiatus. Glendora will be back in 6 months or less to the United States District Court in White Plains to Judge Cattell. Glendora still cannot see why these federal defendants would not be sued in state court. There was no diversity of citizenship. Everybody was a citizen of the same state, the state of New York. That means that one wasn't in New Jersey, one wasn't in New York, one wasn't in Connecticut. They were all in the same state. All the litigants were residents of the same state. Defendant waived right to move by filing an answer in state court. Richard O'Connell filed an answer in state court, and so did Novinsky. So that should have ruled it out. All defendants did not join in the removal action. Some of the defendants didn't say that they wanted to be removed to the United States District Court. It is a comedy of errors, all right. Plaintiffs' claims were based on state law. These administrative claims are all physical. It seems that Glendora's claim should be excluded and therefore upset Novinsky's apple cart. Another thing that is bad about having to file an administrative claim is that everything is by mail or long-distance telephone, and it is face-to-face negotiations that are the most productive, even with a face like mine. Just the same as Judge Cattell denying a pro se's right to oral argument. Compromising. Attorney General or his designee may arbitrate, compromise, or settle any claim cognizable under Action 1346B of this title after the commencement of action thereon. And I asked Judge Cattell, and I asked Judge Cattell here, maybe she will. That'd be Mary Jo White, the United States. Maybe she will. That'll be Janet Reno. But then why didn't she before? Novinsky's citations of authorities, Soriano, Mitchell, Kemmerer, have no relevance to Glendora's cases. Rereading this motion to dismiss by Novinsky is such a shameful cop-out, such a substandard way for United States employees to act. They should face what they did wrong and atone and reform. This is the paper she should have had in by April the 23rd. There is something very wrong that two judges, Fredman and Cattell, let Novinsky get by without answering a summons with notice and a complaint for 3 months when she was supposed to answer it in 20 days. All of this looks great and sounds great on TV. You get a chance to hear and see it first before the federal agencies to whom Glendora filed her claims. Also, the FTCA, the Federal Tort Claims Act, taking so long to rule on a claim makes a petitioner lose out because of inflation. All the time, inflation steadily goes on. Federal Tort Claims Act, so that $12,500 isn't worth in 6 months what it was worth today. The Federal Tort Claims Act did away with the sovereign. Why does Novinsky bring it up in her motion? It is over. Interpretations of the Federal Tort Claims Act, two of which Novinsky never dealt with. One of these is, in the same manner and to the same extent as a private individual under like circumstances. You can sue the United States of America in the same manner and to the same extent as you can a private individual who committed similar torts. There is authority for the view that the words, quote, as a private individual, unquote, as they appear in this opinion, are not used as words of art or as limitation, but rather as a descriptive manner to indicate that the United States should be liable in the same manner and to the same extent as anyone else. Another statute in conferring jurisdiction on certain federal courts refers to actions for injury or loss of property or personal injury or death caused by the negligent or wrongful act or omission of a government employee, quote, while acting within the scope of his office or employment. So those are some interpretations that have to be dealt with. Did you know that a United States District Clerk Did you know that a United States District Judge is not an employee of the United States? The definition of an employee of the government in the Federal Tort Claims Act has been held to be sufficiently broad to include the regular personnel of a Veterans Administration hospital, a postmaster, and a real estate agent engaged by the United States to supervise a government housing project. But on the other hand, a judge of the United States District Court and his trustee in bankruptcy and a federal prisoner have been held not to be government employees, such as compensated by the Federal Tort Claims Act. And here is today's joke. Did you hear about the minister who was so religious that even his contact lenses were stained glass? This is a notice of motion cover sheet. It's really an affirmation in support of something, but I guess it'll do. And you have to put that in. And this was sent to the United States Bankruptcy Court in Westbury. This is Judge Hall's court. And it's in regards to Atlantis Lawn Sprinklers Incorporated, who is a debtor in this bankruptcy, and Richard E. O'Connell, trustee in bankruptcy of Atlantis Lawn Sprinklers Incorporated. He is the plaintiff, and it's against Tri-State Irrigation Systems Incorporated and Scott Lord. Tri-State is Jeffrey Barnes and Jan Stahl. They are the defendants. And you remember I told you how the trustee, Richard O'Connell, made an application to Judge Hall to resettle the stipulation with Scott Lord because Scott Lord defaulted on the payments. And so Richard O'Connell gave Scott Lord another chance, and Scott Lord made up those payments. What were they, June and July? And then he charged $2,000 more as a cure fee, making the judgment $14,000 instead of $12,000. Okay, this is Richard O'Connell applying to Judge Hall for Judge Hall to permit this. So this is Glendora. Creditor Glendora's affirmation in support of panel trustee O'Connell's motion for new stipulation. Why, Trustee O'Connell, I hope he's sitting down. This is the first time Glendora's ever supported him on anything. Right, Katie Cat? Please take notice that creditor Glendora supports Richard E. O'Connell's motion for a new stipulation and will appear at the hearing on his application before Judge Robert John Hall in the courtroom of the United States Bankruptcy Court, 1635 Bravado Road, Westbury, New York, on October 5th, 1993 at 9:30 a.m. White Plains, New York, September 3rd, Glendora, TV ads, Box 532, Scarsdale, New York, 914-949-9495. In support of the motion stated above by panel trustee O'Connell, creditor Glendora has to give him credit. O'Connell is the only individual Glendora has known personally to make Scott Lord pay. And this is over a period of 7 years. It was 7 years ago, September 8th of 1993, that Scott Lord ripped off Glendora. And in all this time, Glendora has never met personally anybody but O'Connell able to make Scott Lord pay. To quote Kipling, "You're a better man than I am, Gordon's gin." The amount Scott Lord is getting away with is not fair, $14,000. Well, it's very good, Katie. All right, we got that settled. But at least when Scott Lord defaulted, as Glendora assured you repeatedly he would, the trustee jumped on him and rescinded the stipulation, garnished Scott Lord's wages with the sheriff, and penalized Scott $2,000. Scott Lord is getting by even with this, virtually scot-free, in that the creditors lost $108,000, and this creditor has reason to believe from her telephoning around the whole country a whole lot more. See, that's what he said he owed creditors. And a $55,000 original judgment and a judgment against Tri-State, Stahl & Barnes for $105,000. That's what the creditors have lost. We recouped $5,000 from Barnes and Stahl, Tri-State, and so far, I think it's $10,000 from Scott Lord. At this point, both Glendora and her lawyer, who got her this judgment against Scott Lord in 1988, agree that nothing is to be gained by opposing panel trustee O'Connell's application. And panel trustee O'Connell said in a letter to me last month, he said that he had made this application to Judge Hall to approve this resettlement, and then O'Connell said to me, which I assume you will oppose in your usual something manner. What was it? It certainly was an insult. Charming, that was it. Which I assume you will oppose in your usual charming manner. Well, the trustee is wrong. I'm going to support his application. It is a far cry from what it should have been, and it is a bad record of overprotection of a man who lied, stole, and cheated so many of us. He should have been dealt with more swiftly. This should have been over in 1990 instead of 4 years later, 5 coming up. As the panel trustee said, sinister attempt. These are the very words of the panel trustee. That Scott Lord's sinister attempt to manipulate the bankruptcy court. And as Scott Lord himself said, the bankruptcy backfired. Well, it certainly did. Scott Lord would have got by with it routinely. Oh yes, routinely. They come up, they have the 341 meeting, and it's over. And that's all there is to it. And the client walks out of the 341 meeting room saying to the lawyer, is that all there is to it? And the lawyer says, yep, that's all there is to it. They would get by routinely. If this creditor, Glendora, had not worked 30 hours a week to stand up for what is right and to pursue, ever so elusively, justice. In summary, creditor Glendora supports the panel trustee 100% in his application for resettlement for $14,000 with Scott Lord, dated White Plains, New York, September 3rd, 93. Glendora TV ads, box 532, Scarsdale, New York. And again, that was sent to the same 36 people. And Katie Cat is lying on the next paper to read to you. No, I just don't think there is a next paper to read to you, but I did send everybody, along with the cross motion to dismiss O'Connell's motion to dismiss my complaint, and along with a notice to Judge Cattell that I filed the administrative claims, and along with the affirmation in support of Richard O'Connell's application for resettlement for $14,000. I sent the log, and this is the log, and it is 11 pages long, and this is a daily diary of all the things that happened in this absurd bankruptcy case. And this was the 106th mailing, I believe, 106th mailing. And I want you to know something. This mailing, with his printing and with his postage, cost $102. $102. And this is the 106th mailing. The others haven't been quite that expensive. So somebody has to pay for that. This is Katie Cat and Glendora, a chat with Glendora. And now you are up to date on what happened on Scott Lord between the dates of August the 16th, 1993 and September the 3rd, 1993. Did you hear about the minister who delivered a stirring sermon on gossip and made the error of closing the service with, I love to tell the story. I love to tell the story of Jesus and his glory. We'll see you folks. Take care. Keep the courage flaming. Bye now. Katie. Oh, Katie, you're so pretty. Well, now she's coming to me. Katie? Katie? Katie, on the desk, drinking. If you coax her just right, she cleans up the plate every time. She's 100% kitty. But you have to coach her just right. Yeah, you have to coach her just right. Right? Coax her. That's right. Well, folks, this is September 5th Sunday, just before Labor Day, September 6th. And Gannett Broder have not answered the summons with notice and complaint. They had 20 days to do it, and it was served by mail, so you give them 3 extra days. And it was served on them August 9th, so not counting the day of service, that would be August 10th, so 20 days would be August 30th, and 1, 2, 3 days for mailing would be 31st, the 2nd, and 3rd, so the answer should have been in September 3rd, Friday, and it isn't. And it isn't in September 5th either. So maybe we will have to move against Gannett for default. Maybe we will have to move. So maybe we will have to move against Gannett for default judgment. And the amount of that claim against Gannett is $600,000 for antitrust in the counties of Westchester, Putnam, and Rockland. Other than that, here is what has happened since August 9th, when the summons was served. All 7 green cards were returned to us today, August the 12th, 1993, Thursday. The return receipt requested. Glendora is reading Judge Broderick's rules. He's going to be the judge. He is the judge on the case against Gannett for antitrust. John Clark, lawyer in the antitrust department, requested a copy of the summons with notice and the complaint, and Glendora will make a copy of Curley's golden parachute for an exhibit. The time on Broder today is 1.5 hours. The cost is $2. Glendora left a message on the recorder of a reporter at the New York Times that she had filed an antitrust suit against these 7 Gannett defendants. A policeman asked Glendora to get him a copy of the footage of the fans at the Mets game, August the 7th, Saturday. His son may be in the footage. And so I'm negotiating with Cablevision, that would be Sports Channel, to get that copy for him. I'm also negotiating with Cablevision in Nassau County to run the Scott Lord documentary. The boss is suffering from Moon syndrome. The boss is suffering from Moon syndrome. He carries 1/6 of the weight he thinks he does. August the 31st, 1993, Friday, 1 hour today to copy the golden parachute as an exhibit from the proxy statement. Paginate to 3,613. That's a lot of filing. Talked to a lawyer about lawsuit number 3 against Gannett. The logs are complete for Broder today. And who was the last man to box Joe Louis? The Undertaker. 45 minutes on Broder today, getting ready for the exhibit of the golden parachutes of Curley, etc. And it took the reading of the rules of the Southern District and the logs and the file. Reporter, a mind is a wonderful thing. Editor, yes, everybody should have one. August the 15th, 1993, Sunday, before church, 1/4 hour on Broder to make the title page of the exhibit 3 parachutes. The logs are up to date and the file is fine, and 2.5 hours since Wednesday when the last What Happened was posted. Ed says his uncle has got 30 days so often they are trying to name a month after him. And August the 14th, 1993, Sunday, Glendora started file 36 for Broder. That's outrageous. Gannett is selling for $50.03. Glendora handed in her Exhibit 3, the golden parachutes. August the 17th, 1993, Tuesday, Glendora was in Yonkers, Scarsdale, and Port Chester. Glendora read the court rules, federal and southern. Broder had an article in the newspaper today about chewing gum. It was disgusting. Glendora called the United States Department of Justice, the attorney in the Antitrust Division. Glendora spent 1/4 hour reading the rules. Glendora ought to write a letter to the editor that she agrees with Brodsky and not the judges. The teacher, if you take 51% of 100%, what do you get? And the son of a business tycoon said, control of the company. August the 19th, 1993, Thursday, John H. Clark, an attorney in the Department of Justice, Antitrust Division, he's stationed in Manhattan, who gave us information how to file an antitrust action, and who asked us 3 times for our names and telephone number, and who asked us to send him a copy of our lawsuit 3 against Gannett et al., said this morning that the feds are going to consider whether to investigate Gannett et al. On charges of antitrust on the basis of our lawsuit. Glendora, how long will it take to decide? And Mr. Clark said a week or so. So this turns out to be, as a surprise to Glendora, another action against Gannett and Broder that Glendora did not know would happen. The Department of Justice, the Antitrust Division, can conduct an investigation on its own above and beyond my lawsuit against Gannett Broder for antitrust. Glendora read 3 pages of the court rules for Broderick, and what do you call fake spaghetti? The great imposter. On audio tape 471-1 is another refusal by Milton Hoffman to print Glendora's letter to the editor about Gannett's narcissism with stories in his own paper about Gannett. This is just what one of the counts in the antitrust suit is. Broder has not had a story in the paper for a week. How does he earn his keep? August the 20th, 1993, Friday. Gannett is going for 51 1/4. Glendora bought it at 42. And only a quarter of an hour was taken by Broder to read 3 pages of the Civil Justice Expense and Delay Reduction Plan. The federal judges are a lot swifter in their decisions than the slowpoke judges in the Westchester County Supreme Court. Glendora got a check from a client in the Bronx going on WNBC TV, NFL Inside Stuff. Glendora heard again what Hoffman trumped up about not printing Glendora's letter to the editor about Gannett's narcissism. There is nothing on the editorial page about any standard Hoffman was dodging with. Glendora read 3 pages of the Federal Delay Reduction Plan with forms. Monday, Glendora will be through reading all the papers the court clerk gave her to read. That's federal court. Boss, everything in this office is insured, except the clock, and the employees keep a close watch on that. August the 22nd, 1993, it was only another half an hour before church today. There is just 1 more page for the Federal Delay Reduction Plan to read. The time this week is 4 1/4 hours. Bob, our company has found something that will do the work of 4 men. It's called a woman. Glendora was on David Letterman. Whoops, cut. These are the stories on Brodsky, off the ballot, on the ballot. And it ended up that he's on the ballot. That Andrew Spano lost that one. And it was very interesting to watch the whole process, though, with the appellate division and the appeal. So this is just more little daily activities on Broder, and there's nothing here. I went to Long Island to pick up a check for a new client going on WNBC TV on August 30th. Milton Hoffman says the same dumb thing every time Glendora calls him and asks if he's going to print her second letter to the editor. My second letter to the editor was that I agree with Brodsky. I don't agree with the judges. Milton Hoffman makes a bad showing, as all of the Gannett people do. Wrote a story about Letterman. He wrote a story finally about Letterman, and I think that was in the newspaper. Well, it was on when Letterman went back on the air, which would be August 30th. And is Broder, he writes a critique of Letterman. Can you imagine that? Broder, the boy who couldn't sit down at the typewriter and write a story. Can you imagine that? And caused all these lawsuits and caused all this bad action. Where does he get off with his puerile opinions about Letterman's performance? Is Broder making $14 million a year the way Letterman is? Does Broder mention that Tish lives in Rye? Biff lives in Greenburgh, but Tish lives in Rye. And Broder makes a comment like a kid in a baseball card store. Well, Broder should know. He did a pretty good job of it, Broder writes. Look at that. I'd like to see Broder get up there and do anything anywhere near as well as David Letterman does it. What does Broder know? Has he ever been on television? Glendora was on David Letterman. Glendora showed Broder that clip. It was 8 minutes. This is the story Broder was too lazy and childish to write. Gannett missed a good story, but then they do that every day, and more than one a day. Glendora knew Biff. He was stage manager when Glendora was on, and he told Glendora how to walk onto the stage and not to carry anything. David Letterman doesn't like to have you carry anything when you walk onto his set. A year later, Glendora saw Biff at Rock Bottom in White Plains. And that is where Broder's stories are. September the 2nd, 1993, Thursday, Glendora worked an hour editing Glendora versus Gannett Broder, Chapter 46, about the antitrust suit. It will go into another half-hour program. So there's 47 chapters, half-hour each, on Gannett Broder and their breach of contract, the libel suit, and now the antitrust suit. This is the day Gannett Broder's answer is due to the antitrust suit on September the 3rd, 1993, Friday. So we've gone all over that. And every time that Glendora talks to Milton Hoffman about printing her letter to the editor, he runs away. Glendora talked to Merrill Folsom, who was the former editor of the New Rochelle Standard. That would be way long ago, the 30s and the 40s. And on September the 3rd, 1993, Friday, Glendora did 210 telephone calls. That was to make up for Tuesday, Wednesday, and Thursday because of the bankrupt, getting out that paper about the bankrupt. So Saturday we brought the log up to date, we brought everything else up to date, and so there's really nothing to do on Broder. We give him a couple, 2-3 more days to answer, and then we'll move for a default judgment for failure to answer the summons with notice and the complaint. That's good. That's very good. This is the update on Glendora versus Lydia Gallicano. This case is the illegal rent case. It went before Judge Ruskin. If you remember what the case was about, I charged that I had paid rent, illegal rent, for a year because the house was registered with the White Plains Building Department as a one-family house, and it was rented illegally as a two-family house. And I sued for $20,000. And I also charged that the house had no certificate of occupancy 50 of the 52 weeks that I lived there. And Judge Ruskin dismissed my complaint, and now I'm appealing Judge Ruskin's decision. And here is the title page, New York Supreme Court, Appellate Division, Second Department. And the record on appeal is done. It's 275 pages. The table of contents is all typed. That took a long time. To paginate it took a long time. This is the statement pursuant to CPLR 5531. What this does is list all of the motions, all of the cross motions, all of the decisions, all of the affidavits of service, all of the affirmations in support of, and so forth. And it's 2 pages long, and this is the table of contents. As I say, the whole record on appeal is about 270 pages, and the first copy of that has been made. This is the master copy, and the first copy has been made, and that copy will be taken to the Appellate Division in Brooklyn on 45 Monroe Place and given to the clerk, and the clerk will tell whether it has been done correctly. And on the basis of that, if it is done correctly, then you can go ahead and have the other 13 copies made. But it's very expensive to have these copies made and to have them bound. Here's the update for the week of August the 23rd. on Glendora versus Walsh, Alpucci, and Larkin. What happened at 21 Greenridge Avenue, mailing number 23 to 22 people. August the 23rd, 93, Monday, Glendora talked to the Detective Division for 15 minutes. A week of peace except for Roberta and Candy horn-blowing Tuesday. That's the fright law. Remember how we went into that in great detail? And about the police reading the logs, and about the police looking at the videotapes. Number 22 log cost $12 to print and $12 to mail. This is $100 a month of self-defense against lawbreakers Walsh, Alpucci, and Larkin. There were no Larkin offenses last week. 10:10 p.m., Roberta Walsh blasted her horn twice under our dining room window and called Jamie twice. You have to be a special kind of what to be that inconsiderate of neighbors and to be that law-breaking. A car horn is for traffic emergencies. That's what it's for, only what it's for. 10:56 p.m., Candy Alpucci stopped her car under our south bedroom window and blew her horn twice. This was willful, deliberate, and malicious harassment. It is number 239 harassment. These are the inadmirable hornblowers. At 11:07 p.m., when Candy returned, she did not blow the horn. And we know when she returns because she parks a car contiguous to our bedroom wall, and it takes a lot of noise. This is because she illegally parks two vehicles in one parking space. So she crowds her car up against the building, and it touches our bedroom wall so that we can hear her come and go. The motor come on, the motor come off, the keys, everything. Summer camp is a good institution. Parents pay $1,000 so their daughter can bring home a 50-cent pot holder. Time on wall today is 1/2 hour. August the 24th, 1993, Tuesday, 7:22 a.m., Glendora left a message on Porzio recorder about the inadmirable hornblowers of last night. August the 25th, 1993, Wednesday, research at the Pace Law Library about order of protection and citizen's arrest. A day of peace it was. August the 26th, 1993, Thursday, Jamie with another boy. I can't play here. Glendora's here. Roberta, oh, you can play here. That was at 7:24 p.m. 9:03 p.m., Candy Alpucci blows her horn near our bedroom window. Her car is parked too close to the building. 1:18 p.m., more car noise and building. 1:18 p.m., more car noise, and the car is too close to our building. And it's 94 degrees, and the humidity is about 94. August the 27th, 1993, Friday, a day of peace. Glendora took 1.5 hours to screen chapters 4, 5, and 6 of the wall videotapes for the fright evidence to show her lawyer. 94 degrees and 94 humidity. One letter returned in the hallway. Glendora left it there. It disappeared. Porzio about the banister and the newel post and about Candy horn blowing and about two vehicles squeezed into one parking space and about the law on fright. It was a day of peace. August the 28th, 1993, Saturday, Roberta and Daniel Walsh do not harass us anymore. Glendora read about getting an order of protection, a day of peace so far at 7 p.m. and a big thunderstorm. Oh boy, did we need that. August the 29th, 1993, Sunday. Today was a day of peace until 6:25 p.m. when Candy drove 4 people into the backyard. One of them said about Ginny, friendly cat. Candy said in a loud voice into our bedroom window, yes, a friendly cat. And it's too bad you can't say the same for the owner. There was no provocation for this. Glendora said nothing before, during, or after. That's harassment number 241. And August the 23rd, 1993 week, Glendora did not send out a what happened log for August the 23rd, 1993 week. August the 30th, 1993, Monday, we went to Deer Park, Suffolk County, and picked up a check for a new client going on WNBC TV. Then we sped to Manhattan to have his videotape edited and bumped up to 1 inch, which is the only format that WNBC TV and the other broadcast stations will accept. And to WNBC TV, the 7th floor security, where Glendora used to see David Letterman. No David Letterman now around 30 Rockefeller Plaza. 11 years it was that way. Glendora, let's see, Cut. 9:30 p.m. Roberta blasted her horn 3 times into our dining room window. Harassment number 242. You have to have a special level of intelligence not to know that an automobile horn is for preventing automobile accidents only. August the 31st, 1993, Tuesday, Glendora went to the cellar and out the east door to get Jenny. Roberta was sitting in the cellar smoking. As Glendora passed through the cellar and got Jenny in return, Roberta did not say a word. Now this is the way it should be. There was no harassment. This is what she and Daniel should have learned a long time ago. This was a day of peace. September 1993, September 1st, 93, Wednesday. We have no front door. The door closer came apart yesterday afternoon and the place is wide open day and night. Kevin Larkin is around and makes feeble attempts at harassment, but subsides. Maybe the letters to the Chief Klein help. We never see his parents around. Kevin likes to belch loudly enough to be heard all over the whole property, hack and spit. How can parents allow such uncouth Neanderthal behavior in public, but score it as a day of peace? September 2nd, 1993, Thursday. It was a day of peace all day until 7:22 p.m. when Candy Alpucci, unable to control her law-breaking urges, blasted her horn. This is what people do who are under the influence of a whatever substance. That was harassment number 243. That was harassment number 243. September the 2nd, 1993, Thursday, when we came home from editing videotapes at TCI and were unloading the videotape equipment from the Lincoln, Candy Alpucci came into the front yard and blasted her horn 10 times. Again, there was no provocation. We said nothing before, during, or after. She began talking in a loud voice to Roberta, who was shouting again out her second-floor kitchen window like Mrs. Goldberg. We videotaped this. When we came into the hall, Roberta let go one of her Neanderthal harangues of crudes and rudes. We videotaped that. Again, this was unprovoked. We did not talk to Roberta before, during, or after. That was number 122. That was number 244 and 245 harassments. Then Roberta, after we were inside our home, came noisily down the stairs and through the cellar to go and collude with Candy. At 8:02 p.m., the horn blowing it came again, and there was abusive language. The horn blowing and abusive language happened at 7:23 p.m. At 8:02 p.m., Roberta went by Glendora's south bedroom window and shouted a word of 5 letters, begins with B and ends with H. Well, at least we have found the law to drag this cave woman into court by her hair. Franklin is Glendora's witness. Glendora should have called the police.